how do we actually make this work for a country as big as ours. So let's dive right into it. I think the core of the conversation, particularly around data regulation in India, cannot be had without discussing the Sri Krishna Committee report and the draft data protection bill that's been tabled. Sunil, why don't we start with you? When we spoke, we decided that it makes sense perhaps to provide some historical context in which this law has evolved. And then maybe you can go into a few things that you like about the bill and a few things that you don't. And we'll go around the panel getting the same comments, and then perhaps we can spend some time debating those things.
Thank you, Sahil. I'm going to mash all your questions into one big lump and try and talk about it
Could you tell us what the question is, though, now in your head?
I think I'm the person with the most gray hairs on this panel.
Oh,
so I won't
be competing, but go ahead.
So I won't start with the Sri Krishna bill. I'll start with our IT Act, and I'll also start with the AP Shah report. I was on the AP Shah committee and contributed to that report. So if I look at the new draft bill that we have, and if I look at what was in the AP Shah report, and also what was the key feature of the IT Act, and this is a specific provision, 43A. So what was interesting about this provision is it offered three choices to data controllers or data fiduciaries. The first choice is you enter into a contract with the data subject and say, I'm not going to protect your data, and that is fine. That's one option. The second option is to comply with the most complicated technical standard when it comes to cybersecurity, an ISO standard called ISO 27001. And just doing an annual audit to comply with this standard meant that you would spend millions of dollars. And I don't think even corporations like Facebook comply with ISO 27001. But the middle path, since we are in India, we must always talk about the Buddha and the middle path.
Yes.
And the middle path that was offered is, why don't you come together as a particular sector? Why don't you evolve self-regulatory codes and standards? Why don't you institute a self-regulatory organization? Once these self-regulatory standards have matured, please bring it to the regulator. The regulator will then bless it and then enforce it in a co-regulatory regime. This was what 43A of the IT Act envisioned would happen in India when it came to data protection. Unfortunately, this never happened. The regulator was sort of distributed. The court of first appeal, in a sense, or the court of first instance, was the office of the IT secretary. And across India, IT secretaries had enough of work on their plate. None of them were thinking about how to enforce 43A and how to encourage various sectors to come up with self-regulatory standards. And this is where I will try and pick a fight with Smriti. So when it came to the Sri Krishna committee process, there were a bunch of us that said we must go for co-regulation because co-regulation is an important route. The regulator will never have enough capacity to develop specific technical standards for individual sectors like the fintech sector. And there were others like NIPFP, at least in one of its submissions, which said that co-regulation has failed us in the past, and we don't think co-regulation will work in this context. So that's really a big divide. For me, the good part of the data protection draft bill is that it's very similar to GDPR. In some parts, I would say it's even GDPR++. So it's very good for us as citizens. The bad part of it is that it is a very old-fashioned approach to regulation, where you assume that you have a command and controller regulator with all the expertise and all the capacity, and somehow they are the source of all solutions. I would have preferred at least some amount of co-regulation in the bill and in the approach that we are taking. I'll stop at that.
Excellent. So what we like about it is the fact that it resembles GDPR. We should definitely try and start framing things outside of what white people have done, which we have our own problems. So I have a problem with that framing. So I'm going to push someone to say, What are the good things about GDPR that this thing has? Because just having a borrowed framing is something that I think doesn't suit us as a people. That's one of the things that I'm going to push everyone on. But let's move on to Sanjay. You want to kind of comment on what your take on the law is? What do you think it has going for it? What do you think it needs to improve?
So, in terms of the law, and there's a long history to the law, but more recently, I think the concept of consent has become central to a lot of conversations around data. And I like the fact that, of course, there are some exceptions, as Sunil has pointed out earlier, but broadly, consent has been placed at the heart of any conversation around a person's data. And I think that's a framing that, in particular, we've been very positive about, because end of the day, we believe that while it is the duty of the fiduciary to protect my data, but the very fact that they have it in the first place and the fact that I, as a citizen, have access to it is as important as anything else. So I think that was the first part of what I liked about the way this law went around it, was to improve the need for consent. The second part is, of course, around data fiduciaries, where, again, if you have consent and it's really widely distributed, you can't manage consent so easily. So the concept of a data fiduciary who comes into certain domains allows for that consent to be managed in a slightly more manageable manner. And so, we're seeing that with, for example, the first instance of data fiduciary comes around with the RBI NBFC account aggregator model, which is where, again, now you're starting to see a single entity which is able to manage consent within a domain, and hopefully that will lead to the data within that domain being both protected from misuse and at the same time available for use under consent by the citizen. And so that's the second part of the law, which I think I like a lot. What I don't like about most of our laws, and this law is no exception, is how prescriptive it is. Which means that when the world changes around us, it becomes hard to change and keep it up to date. And so that's something which I think we have, most of our laws and regulations tend to be ultra prescriptive, and this is no exception to that rule. And that's the one thing I don't like about it.
Excellent.
The third piece is around penalties. Fourth, so two I like, two I don't. And sometimes I think those penalties under this law tend to be a little more draconian. And so that's one part of the law which I think could be looked at again.
Excellent. And Sunil, we'll come back. One of the things that would love for you to respond to is, you were talking about the role of an intermediary, and we're talking about fiduciaries in managing consent. That's something we should discuss once we're done with the opening remarks. Smriti?
Yeah. So before going into the good, bad, and the ugly of the law, I'm going to respond to Sunil and, in that sense, set a context to why we took the position that we did, And, if we look at this point where we are on this whole data protection debate and why we are having this conversation, a lot of it is a pile-up of the imbalance of power between states, bigger states, smaller states, states that control data, states that don't, and also between corporations and states, right? So whether you have a law or not have a law, as on date, you are not, in terms of state capacity, enforcement capacity, at a level playing field even between a large corporation and a large enough state like India. So I worry about a co-regulation framework. I worry about frameworks like that from the perspective of where it's going to lead. What it might sound like on paper sounds like a more egalitarian approach, but I worry about how it will play out in practice. And, data protection is actually only one of the lens in which all of this dynamics of power is playing out. It's also about taxation. It's about cybersecurity. It's happening in many, many domains. And what we are seeing are two tussles, which are actually two forces. On one hand, states are trying to exert this kind of power and control over our data, this idea of data sovereignty. And on the other, we are seeing other states like United States, Canada, Japan, using trade agreements as a route to try and push back on this and say that, we want to promote free flow of data, we want to allow e-commerce to thrive, and, so there is this tussle which is taking place, and I think we need to place our data protection debate within that tussle. So with that response on this particular bill, I think as a person who advocates for strong privacy rights, I'm quite happy. And in support of Sunil's point, it's not just that it is reflecting GDPR, because GDPR itself is reflecting 30, 40 years of thinking around what should be basic principles of data protection. And that's coming from OECD, that's coming from, APEC. It's coming now widely recognized about collection, processing, data minimization. These are certain norms which have come to be evolved as this is the base level of data protection that you need in today's economy. So in that sense, I'm really happy that the law reflects all of that to a large extent insofar as the substantive provisions are concerned. When we come into the enforcement framework and the implementation of all of this, that's where I start worrying, because as I was discussing, it seems like we have borrowed from GDPR on the substantive part of it, but stuck to our boilerplate Indian procedural provisions when it comes to creation of the Data Protection Authority and the kind of accountability and transparency. And we can talk a little bit more about this later.
Let's come to that. I think which aspects in particular we should dive into. But before we get into that, Rob, you want to talk about one of the things that I think you have such a wide context. You've engaged with multiple governments. You've looked at multiple versions of law that purports to do these, purports to protect data. How do you look at this law? What are the things that you think we've gotten right? What are the things you think we could do better? And how does Facebook think about its engagement strategy with the Indian market as a whole as a result of this law? And no one can look into the future, but where do you think this is going to take us?
Sure, absolutely. And I think you make a really interesting point, which is it's very easy to look at different legal regimes and identify distinctions between them. And a lot of the philosophy that underlies the draft bill and that underlies other regimes in other places is this OECD framework and the principles that exist around how data should be protected. I think against that backdrop, one of the things that I think is really important and a contribution of this draft bill is this idea of a data fiduciary and even just using terms like data principal and data fiduciary as compared to data controller and data subject sends the message that there's a trust relationship between organizations that hold data and the people about whom that data describes. And I think this is really important. This is something that we think about a lot at Facebook from a business perspective. The reality is if people don't trust us and don't think their data is protected, they'll stop using our service. And I think that's an important concept in thinking about data regulation more broadly. And I think that's something that you don't see in other legislative frameworks yet. And so I think that's an important contribution. But I think that by itself is not enough. One of the other things that I think is really important is adding specificity around what it means to act as a data fiduciary. What are the rights that people should be given, should have in their data? And so this is things like the ability to access their data, the ability to delete it, the ability to port their data, to bring their data with them. And this is something that we've invested a lot in. On Facebook, you have the ability to download information and bring it with you, and we're investing in some integrations with Google and Twitter and others around an initiative called the Data Portability Project to do that. So I mean, I think those things are really important in sort of empowering people to control their data, and that's a really interesting contribution. On the other side, I mean, I think one of the challenges that this law confronts is we think about the idea of consent, and it's sort of framed as a concept that is central to the law. But the Sri Krishna report recognizes that there are a bunch of different ways of using data and that consent doesn't look the same in all cases. So for example, there's the concept of reasonable uses of data that don't require consent, recognizing that, rather than asking people to read a very long boilerplate document and click a button at the end, I think most of us in this room, even though we're many of us experts in this field, aren't reading every privacy policy that we're presented. And so if that's the case, then I think one of the things that the law recognizes is we have to treat that differently and differentiate between the things that are important and the things that are typical. And so the law frames that up, but then doesn't get into a lot of detail about fleshing out what are the reasonable uses, what are the things that can be susceptible to implied consent, what are the things that require explicit consent. So I think there's more work that needs to be done there. You mentioned penalties. I think one of the challenges of particularly framing penalties as either as criminal penalties, which discourage people from getting into the field, or as percentage of global revenue, is that it creates this sort of trade war where different countries are essentially taxing each other's companies on global revenue. And so I think that's a challenge. But the last thing I'll identify, which we haven't touched on, is age of consent. So the bill frames up 18 as the digital age of consent. And I think that not enough discussion has happened about that, because I think if we're thinking about data privacy regulation as a way of empowering people, particularly when you're talking about 16, 17-year-olds who may have a privacy interest of their own and may want to have the ability to communicate and share information about themselves with people independent of their parents, it creates a really significant downward pressure on that. And so I think thinking about what are the right ways to protect teens as a part of this framework is a really important discussion that we should also have.
So a couple of interesting points where I observed that a couple of panelists are saying two different things. One is around being overly prescriptive versus not elaborating enough on the law. So how does one strike the balance between, defining reasonable use? There could be multiple, I myself could imagine easily a 10-page document that are listing out all the reasonable uses, and that won't even begin to cover reasonable uses. At the same time, Sanjay talked about we being overly prescriptive. So where does that conflict, how do you resolve that conflict? I think that's one question. The other interesting observation I'd like to make, that I gave 4 people an opportunity to talk about what they don't like about the law, and data localization was not brought up once, which is strange. We'll go into that. Does that mean we're all cool with it? In which case, let's carry on. So that's an interesting aspect of regulating a new sector, particularly in data, saying how much do you say on this topic? And so the real question I have, and anyone can take this, is that have we said enough? Have we said too much? Have we not said enough? Where are the areas where we should elucidate? And where are the areas where we should hold back? Yes, Sunil, please.
Yeah, so I think you can read both comments in a consistent fashion. So there is one panelist asking for more detail, for the law to be more prescriptive, but I think the ask is specific to legal concepts. So for instance, the necessity test in India does not have evolved jurisprudence like the very same test in other jurisdictions. So therefore, the law has to do some heavy lifting and make it absolutely clear what does it mean that this piece of data is necessary for this particular operation.
And in your opinion, has the law done so?
No, and that's where we need more detailing. But on technical implementation,
right.
For instance, what counts as a reasonable anonymization standard, the law should be less prescriptive so that, can I use the bad word again?
Please.
Co-regulatory standards can also emerge. So that's where I say, so I don't see those two comments as
being at odds with each
odds
other.
at all.
And what of, since we're talking anyway, what of the intermediaries and the role that an intermediary or fiduciary has to play in terms of managing consent? I know you have some opinions on what the role of an intermediary should be, how much power should be given to them, what kind of responsibility should be there. That's something that I'd love to get your take on.
Yeah, so it's, I think, two very specific recommendations. One, as far as the law itself is concerned, and the second, on how we go about developing a standard to implement what is in the law. As far as the law is concerned, the intermediaries aren't prohibited from charging anybody for their services.
Sure.
Yeah? So there is a sort of automatic conflict of interest that emerges. To give you a simple example, in the Netherlands, if you have an insurance agent selling you insurance, then the insurance agent is prohibited from making any money from the insurance company. The only actor that the insurance agency can, or the agent can charge, is the customer. We don't have a similar law in India, so many insurance agents sell really bad policies to our customers. So a simple realignment or constraint on the economic incentives for intermediaries just fixes it and makes sure that the intermediaries serve the interests of uneducated Indians, Indians that can't read really long privacy notices. Just for Tetris, just to play the game Tetris, if you add all the privacy notices, they are almost as long as the Lord of the Rings. So nobody can read them even if they want to read them, and so on. So that's the small realignment that is necessary from the perspective of economic incentives. What iSPIRT and others working on India Stack have done is proposed the DEPA standard. But unfortunately, the DEPA standard is not working as a standard as per a technical dictionary. Standards are usually RFCs. So we all use email and SMTP, POP, IMAP,
Sure.
the standards
They're
that are part of
Yeah.
email are still RFCs.
What is an RFC for the
An
benefit of
RFC
the audience?
means that it's a request for comments.
Right.
And all these standards remain RFCs. That means they are developed transparently. At regular points, people are invited to make comments. Those comments are responded to. The RFC is improved. The next version is released.
So your
So
criticism
not
is
only-
particularly in the way the standard has been developed
Yes.
and the consultative process or lack thereof that has been there as the standard has been developed. Is
Yes,
that,
and
is that fair?
not only should the standard be developed using the standard RFC protocol, it should also then be exported to the IETF, where similar standards are being developed, so that not only Indians benefit from the public good that the iSPIRT team is creating, but also the globe benefits from that particular
Sanjay, do you want to
public
address that? I think it's a...
Yeah, I mean, look, clearly there is a process to develop standards which was built by the IETF and the W3C, and that process could be an RFC where somebody puts out an RFC and people comment on it. It could also be a finished product which somebody could take to the standards body and say, here, I've built this thing, please standardize it. We saw that in the case of JavaScript.
Or
It is
PDF.
Yeah, so basically, we have seen multiple processes to build standards. So there's no such thing which would say that a particular process is a golden standard for standard making. On the other hand, there is value in getting a community to work together to build something that works for everybody. And frankly, I think we should see how we can move towards that direction. I don't think that's something that, iSPIRT has said that this is something we will not do. So I really don't see that as being a negative issue. Clearly, the community should come together. The problem is if a community comes together, they should have alignment of goals. Otherwise, we've seen standards taking for years to even move past certain processes. So I think there is this need for speed and alignment and comments and so on, which I think we need to figure out the right balance. I don't necessarily think iSPIRT has the right balance, but frankly, I haven't seen any other attempts out of India that have even made progress.
For the benefit of the audience, the DEPA standard, the conversation that's happening is something called Data Empowerment and Protection Architecture. It's basically a standard for data sharing within the framework of the larger data protection bill that has come in, and includes something called the consent artifact, which essentially is an XML file, a markup language file that lists, who's giving permission for what purpose, can they store it, can they not, etc. All of these little granular things get specified. So it is a technical protocol. At the same time, it has to fit within a legal framework, and that's what the discussion is on.
So clearly, we would love to see a community come together and build the next generation of standards that serve us in the country and globally on many of the things that we are working on. But it does require that, at least you have a cohesive thought process. Otherwise, it will go nowhere. And
Smriti, you had some comments?
Yeah. I wanted to come into your earlier question on fair and reasonable processing or principles in the law and whether it's over-prescriptive or under-prescriptive. So, a law of this nature which is going to apply across sectors and is cross-cutting in that sense, I believe necessarily has to be principles-based. But what we would have liked to see on, and specifically on this section, which is section 4 of the law, is on fair and reasonable processing. That's one of the principles it sets out, and it's particularly important because in all of the exemptions that it makes, like for something like, processing by the state for security purposes or law enforcement purposes, this is one of the very few provisions that continues to apply. So it's really critical that we have some depth and some understanding about what this provision means. And of course, you can't define the circumstances which will be regarded fair and reasonable, but some sort of guidance in the law itself, because otherwise you will have a DPA employee, you will have a company employee, you will have a police officer.
Different people will have different
Everyone
standards of what is fair and
interpreting it
reasonable.
in their
that's
own
fair.
way, yeah.
No,
and we see this kind of thing having been done in the past when, the Competition Act was enacted in India, What the law did was that a lot of principles which came out in case law in other jurisdictions like EU were coded as provisions in the Indian law. Instead of just leaving it for interpretation for times to come, those became actual provisions, and some of those principles, I think the law would benefit from that.
Excellent.
Yeah, I mean, I think you're alluding to a comment that Sunil made earlier about sort of the interaction between between specificity and prescriptiveness versus flexibility. I mean, I think if I think about my role at Facebook and a lot of what we try to do, fundamentally, my job is to understand what is required and what people are expecting of us. And I mean, I think that's both what's required in the law and also what our community wants us to do, even where it's not prescribed by law. And it's those kinds of situations where fair and reasonable isn't clear, and different people have different expectations of what happens, that that you have bad outcomes. Because if your goal is to have good privacy and nobody can agree on what good privacy is, or you don't know until you've messed up, then you're going to end up with bad outcomes, and then people are going to pay the price. And so I think providing more clarity on those kinds of concepts is really important. It goes back to also my point from earlier about reasonable uses. One of the things I think is interesting in the discussion that we're having, though, is we've been talking about the role of different stakeholder groups, right? What is the role of legislation? What is the role of the regulator? What's the role of regulated companies? And what's the role of standards bodies? And I think when you think about some of these issues, which a lot of the issues that we're kind of alluding to but not really hitting on are design problems, right? Product design problems. So when you think about the thing that the person interacts with, it's actually user interface design. And I think that's one place where all of these different pieces really have to fit together well. And it's not going to be the case that legislation is going to prescribe, okay, if you're going to have a consent interface, it's going to look exactly like this. Because the reality is, most of us, when most privacy laws in the world were written, we weren't all carrying around these little phones in our pockets. And, so the interface that we were thinking about when we were writing the law is very different from the interface that we're talking about now. So I certainly don't think, to your point, Sunil, that a law should say, okay, well, on a mobile phone screen, it must look exactly like this. But I do think it needs to provide enough clarity about what's required, but also leave space for that design to happen. And then I think companies, experts in the field, the regulator, all need to come together and look at, in different situations, what is the right way to communicate about this. And again, I think we should probably all agree it's not going to be long boilerplate documents. It's going to be making things intuitive to people, recognizing that different people consume information about privacy in different ways. Sometimes it's a very clear, do you want to agree to share this information with this entity? Sometimes it's going to be more intuitive in the way that you're using services. And some people are, I mean, we've talked about literacy as a challenge, right? So some people are not going to want to consume and make their choices that way. And so it's even more important to make the way that data is being used intuitive as a part of using services. So these are all challenges, but I think it goes to your question about sort of the interaction between prescriptiveness and flexibility, because you need to be clear enough about what the legal standards are and what's required to be done, but then also leave room for this interaction that happens later.
No, that's actually a great point. Sorry, Sanjay.
So I actually wanted to add a point around innovation, because one of the things that you've seen in certain laws is saying that, if you're below a certain scale, this law shouldn't apply to you.
Right.
And because that then allows innovation to happen at a lower scale, and otherwise we end up with the same bar for everybody, and so for a young startup to come up and start is almost impossible. So in fact, a lot of times what laws do is cement the monopoly of the leaders, and they let the innovators not enter. It becomes a gate that's closed behind them.
Yeah.
And so that's something which is again missing in our law is the proportionality, where if you are a small company and you have a very small amount of impact, you don't have the freedom to go out and innovate. So that's the third thing I would add to what I don't like about the law.
And how would one go about even addressing something like that? Because that is a valid criticism of a lot of the kind of burdensome regulations that might come out
So
of this kind of law.
PSD2 starts by saying nothing in this document shall apply to a company with revenue under whatever. I mean, it's not unheard of.
So I mean,
So not GDPR, but PSD2 does that. So the point is that it is completely possible to write.
Is that
a
the best
law
way to do it?
Yeah, I think the challenge is, what's different in the technology sector particularly is it's possible for a very small company with few employees, limited revenue, to collect the data of millions of people and potentially to have very significant scale, or even to have
also possible for a very large company to have very little in revenue.
That's right.
I was a
Which is
VC
fair, yeah.
in a past life.
So
size and revenue is not correlated.
yeah, fair enough.
But you could do it in terms of number of people. It could be in terms of amount of data. it doesn't, like PSD2 specifically deals with money, so it actually talks in terms of that.
Yeah.
But perhaps it could be with, if you have less than 100 people whose data you're doing, so perhaps you're an employer and you've got 100 employees, then you shouldn't be bound by these rules.
That's an excellent suggestion. We should probably look at the number of people's data that you're processing and maybe create some exemptions on the basis of that.
Yeah, I think that one of the places where you hear that criticism leveled the most is in frameworks that are very prescriptive and that are very formalistic in their approach. So if we're talking at a principles level and we're saying, okay, you need to make sure that you collect appropriate amounts of data, you need to tell people what data you're collecting, let them see the data if they want to see it, these kinds of things which are included in the law, those are things that I think small entities probably could comply with. If what you're saying is you have to fill out very complicated forms and have, corporate agreements and corporate frameworks and these sorts of things that require, companies like mine have a lot of lawyers that work on these things, right? That's clearly isn't accessible to a very small entity. And so I think, it may be that, if you're talking about 3 people, who have a very small business, then we're not talking about that situation. But I think when you're talking about something that's larger, that's serving the population, the right way to handle it might be not to say they're out of scope, we're not worried about whether they violate privacy or not, but instead to say we need to adopt principles that are scalable, and so that even a small entity could think about what data they're collecting and make sure we do education for our developers to try to educate them about these kinds of concepts, even if they're small, and then say we're not going to adopt the kinds of formalistic requirements that require you to have 50 lawyers to comply with them. And that may be another way of getting at the challenge that you're addressing.
One of the interesting things that came up in a roundtable discussion that we had yesterday, it was a point made by a gentleman from Infosys who leads data privacy for them, was, and that really stuck with me, right? If you're at a certain station in life where your day-to-day meals and just existence is a challenge, then identity is something that is key to those people, so that they can prove who they are and get the benefits. This could be direct benefits from the state, or it could be health benefits in the form of insurance, could be other benefits as well. Whereas as you move up in life in terms of income, so to speak, or if your standard of living increases, then anonymity or anonymity is something that someone like in our position would kind of value very greatly. How does a law balance those two? Does our law do a decent job of that? Is this something that can? One of the real questions we ask of any law in India is that we are so many countries within one country. Does it do a good job of protecting and empowering people at the same time? Anyone has broad comments on this? Yes, Smriti.
So I think, when we look at this law, we need to see where is the state coming from. And in all of this conversation around data pressuring, there is this presumption, it is paternalistic in the way that there is a presumption that we don't understand what's happening with our data. There is potential harm to come out of it, which we don't, whether educated or uneducated, are not in a state to assess right now. So here is a base level. So, I worry about this argument saying a poor person's privacy versus a rich person's privacy and notions of privacy and that graded thing, even though in reality it may be harder to explain to someone who's struggling, with the day-to-day meal kind of a problem, why privacy is important and why your data is important versus communicating it to someone, say, in this audience. But that doesn't mean it makes it less important or less, essential to ensure that base level of privacy is available to everyone.
Fair point.
So, so I think what the law does in terms of setting the level of privacy is the base, and if people want to contract beyond that and they value their privacy in certain ways, they're free to do that at a commercial level when they deal with the relevant entities and switch from entities and do all of those commercial decisions that, we as autonomous individuals are capable of.
Excellent.
I actually want to add to that. The privacy judgment that came out last year was clear that there is a right to privacy, and it didn't actually go out and elaborate what privacy means. But certainly, after that, it's very difficult for you to make an argument that privacy matters for a particular group and not for another group, because it's now a fundamental right. So from that perspective, the way that the courts, the government, and the people have to see this is very different, because it's gone to a very different level.
Fair. Excellent. So before we go into enforcement, I wanted to leave a tiny window open for anyone who wants to comment on data localization.
Actually, I do.
There we go. Let's go around the table.
In my view, the data localization law should not be a provision in the data protection law. Ideally, we need a separate data localization law. And we have a variety of types of data that have to be regulated by such a law. The first is military intelligence and law enforcement data. It should be absolutely clear that just like the US, that we are going to mandate data localization for all that category of data. The second is e-governance data. So there should be a law which says that you can't use Twitter Saver as your e-governance system, that you should build your own sovereign e-governance systems. And wherever it makes sense, that means there is no reason for the data to travel outside the territory, then all that data also should be localized. That will really help the local industry, especially those that use free and open source software, to start provisioning services for Indian e-governance. Then you come to other categories of data like financial data. And there, I haven't made up my mind yet. I think there are very strong arguments for why it should be localized. And equally, especially when there are international transactions, arguments for why it shouldn't, or what particular type of data localization should be adopted. Because data localization is a many splendid thing. It means many things to many people. So maybe we just want a copy within India so that law enforcement can get it, and we don't need to explicitly prohibit storing a copy outside and so on. And finally, we have global social networks. And while we must regulate them in a variety of ways, including tax regulation, competition regulation, and so on and so forth, data localization, at least as far as I'm concerned, is not an appropriate regulation for corporations like Facebook. If you had a regulatory appetite, I can point you to much more exciting options.
Exciting options to regulate said entities. Excellent. I heard you say tax. That must have given them a bit of a heart attack. Please, Sanjay.
So I think where we are coming at from the perspective of data localization, at least my sort of reading of the tea leaves, is that it comes from this fundamental sense that the government has that they're unable to govern without the regulated entity and the data being in India. And so it's really about this inequality between the state and corporates that has led us down this path. So whether it's eventually made its way into the Data Protection Act or not, the sense seems to be that if we are going to be able to enforce our laws on these folks, then they need to be present in India. They need to have data in India so we can
So it's primarily a law enforcement argument.
It's primarily a governance, law enforcement kind of argument. And I think that's, whether it should find its place into a separate law or within this, I'm not a lawyer enough to argue on that point. But I do see that that's a sense that shows through in a lot of conversations. And this is really reading tea leaves. It's not something which has been explicitly stated as a doctrine.
Fair.
So I would want to put that. And that's what I think we are seeing. We've seen this happen with China.
And you're not attaching any value judgment to it. You're commenting on where it could have come from. So what's your take on it?
No, so like I said, I was having this conversation earlier, right? I mean, China took this decision much earlier, where in 1997 they said you're going to break the internet into a Chinese internet and the rest of the internet. And that eventually led to the Great Firewall, and it has had some consequential, I think, industrial benefits. I mean, the industry is developed in a way which many people wish Indian industry were to develop at that pace. But that's only a side effect. The key reason to do it was exactly this, was to say that we have laws, and if we don't control this thing called the internet, which is this global cloud thing, we will lose control. And hence, that's how that came in. And we seem to be going down that same thinking. And so I'm not attaching any value to that, but I think we should recognize that fear and then deal with that accordingly.
Of course, we're going round. Everybody is going to say what they have to say.
Saving the best for the last.
Yes, indeed.
So I'm going to come into this, I agree with everything that's been said, but I'm going to come into this from a regulatory governance lens. That, what do the principles of regulatory governance tell us? That if you have a problem that you identify, you need to identify a bouquet of solutions and then adopt the least restrictive means to, achieve that goal.
Sure.
So when we look at the problem of data protection and we look at the tool of localization, I don't see that as matching at all. I don't see localization as the least restrictive tool to achieve data protection, because we've seen elsewhere, we've seen it in practice, that there are other norms like contractual obligation, adequacy, etc., which solve this problem. Right? There are other problems which the government is trying to address, and primarily law enforcement, access to data when investigations are to take place, and that's a tougher problem. But I guess, as Sunil was saying, we need to take each problem in its context and then think through what are the options to solve that problem, and then balance against what are the other problems we are creating in the process, whether it be in terms of like the civil liberties you will restrict if you have all the data localized in India, like what is the kind of relationship you're creating between the citizen and the state? Will the state have much greater access to that data? Will it be able to block you in new ways? I mean, those are things we need to think about before choosing localization, and sometimes it will be the solution, but it's not in this case, as per me.
Okay. Not in which case?
In the data protection context.
Oh, so
not for protection.
Blanket, you say data localization is not the solution.
Not the way, the bill has been drafted, where everything, all personal data has to be mirrored and kept in India, because I actually
But
even
you do
worry.
think that it works for something?
It could work for certain kinds of data. If you justify certain data is extremely sensitive, it's very, very worrying if it leaves the country and somehow we cannot ensure that the adequate level of protection will be available somewhere else. You could make a case for this narrow kind of data. There is a case for localizing. A lot of countries do it for health data, for instance. Some people do it for tax data. So, there are cases to be made, but this kind of a sweeping norm is something which is not well thought through.
Fair enough. Rob?
Yeah, I mean, I think a lot of the comments that have been made are really interesting. There are, and it's not surprising that data localization is such a significant topic, because as you point, there are a lot of policy goals behind it. And I think, particularly Sanjay, as you pointed out, the goal of making sure that the Indian government has the ability to govern data. I think one of the two things I would say. One is, I think that there's not a lot of work been done, and I think even though there are pockets of data localization, there's not a lot of work been done on sort of what are the economic implications and what are the broader implications of doing it. What are the benefits to society, and what are the costs? And so I think that's a really interesting thing that needs to be explored as a part of this discussion. The other thing that I would think about is, and Sunil, you alluded to like other unspecified ways of regulating. But I think, in thinking about what are the right frameworks for maintaining jurisdiction and maintaining governance, it's not necessarily the case that all of those need to happen based on data existing on Indian soil. And so I think thinking about whether there are other mechanisms to maintain that kind of jurisdiction, and one actually in sort of the framing of this panel talks about the cross-border privacy rules, the APAC cross-border privacy rules, and I think certification is a model that we haven't talked enough about, but that could be really interesting as a way of addressing some of those things. So I think there's more work that needs to be done.
Could you tell us a little bit more? When you say certification, you mean certifying the fiduciary?
Yeah, so the fiduciary, so the idea is that the fiduciary would agree to certain frameworks. So it would agree that it's subject to certain kind of oversight, either by a government entity or by a local certifying body, for example, and would voluntarily agree to that, and would also assert that it's taken certain steps internally in terms of the way that it's handling data, and that requires a bunch of diligence on the part of the data fiduciary to make sure that happens. But it also has the consequence of giving the government, if it's the Indian government has established this, it gives the Indian government jurisdiction to look after that company and make sure that it takes steps if the company doesn't comply. And so again, to the extent that the goal is maintaining an entity's compliance with Indian law and maintaining jurisdiction, that's a vehicle that could work. And I think one of the additional benefits of a framework like that is that it creates outward pressure from India to other countries to sort of say that we should adopt frameworks that are consistent with that.
Fair enough. So, I mean, far less contentious than I thought it would be. In fact, most people seem to have agreed on the fact that the specification of data localization and in what context and what nuance it is done with should ideally not be explicitly spelled out in the law. It could be something that comes in a separate law or a separate regulation that the Data Protection Authority issues. There are different categories of data that need to be treated differently, different contexts in which localization makes sense versus others. And I really like the framing of the enforcement regime with the minimum possible strain on the system. So choosing different aspects of regulation to actually, different hammers for different nails, let's put it that way. Last 5 minutes to talk about, before we maybe take a couple of questions from the audience, last 5 minutes on the Data Protection Authority itself. I'd like to take a minute to just say that for me the biggest concern on the authority is not the authority itself or the way it's drafted or who, and on all those systemic fixes need to happen, and we should comment on that. Smriti, I know you have a view on that. The biggest concern I have on the authority is who's going to staff it. Right? The traditional model of having people come on deputation and then people come and go, somebody from the audits department will be there, somebody from somewhere else will be there, nobody knows what data localization really is or what data is for that matter, and we're supposedly, ostensibly protecting the Indian people. So how does one think about staffing this? One of the inspirations that I have whenever I think of government authorities is the establishment of ISRO or the establishment of CDAC or any of these organizations, or at least the early person leading it was a recognized world-leading expert, and therefore set a culture in place that, well, at least took many years before it eroded, or in some cases it didn't erode, such as ISRO, for example, which keeps distinguishing itself. So how does one think about institution building in the context of DPA? Rapid fire round of this thing, starting with Sunil.
I'm going to duck the question.
Yeah.
I'm going to, instead of saying who should get the job, I'm going to say what should they focus on doing.
Yes, okay.
Because that's an indirect way of answering that question.
Sure.
So the first thing I'd like to say is that our regulators should not get involved in the theater of enforcement. So there's a lot of political pressure now to take big cases against big internet monopolies and levy huge fines upon them. It's a very risky strategy because they will litigate all the way to the top, and please don't die on that battle.
Yeah, don't die on that hill. Yeah. Yes.
The second thing is, don't let the regulator be subject to denial of service attacks from multiple complainants. So this is what's happened to the European regulators. On the day the regulation came into force, NGOs, my colleagues in civil society, have encouraged massive amounts, millions, thousands of complaints have been filed. So that is one way of overburdening the regulator and making sure that it doesn't do anything useful. So again, somehow the regulation should deal with this excessive complaints coming from a wide range of stakeholders. That is definitely going to happen in the Indian context. The third is a reliance on technology. If transparency and disclosure are cornerstones of the regulation, then it's very important for the regulator to, from day one, have sufficient reg tech. Now, reg tech is usually used in the fintech context, but it can be understood much broadly. Whenever anybody submits documentation to the regulator, if there is no reason why it shouldn't be held and not submitted into the public domain, there should be tools on the regulator's portal where more and more actors in the ecosystem can help with compliance. Because if you don't help corporations or data controllers comply, if from day one you have an adversarial relationship, you're not going to really enforce this law.
Very far.
And these series of suggestions, I'd like to club them all together and call it an orchestrated sunrise, that we need to enter this space very carefully. Copyright law in this country might be 100 years old, but if I search your houses and your computers and your mobile phones, in each one of your houses and on each one of your laptops, I will find instances of copyright infringement.
Absolutely.
So let's not try to achieve full compliance with the law overnight.
Excellent. Sanjay?
Yeah, I do think that, we are wishing that suddenly this body will appear out of nowhere and function flawlessly from day one, and we all know that's not going to happen. And so it is important that the initial set of folks who staff the highest levels of the DPA are carefully chosen, given a lot of time to build the institution, and a phased rollout of this law is extremely important. And I would actually like to start from, the biggest down to the smallest, because that also gives us the innovation benefit.
Biggest down to the smallest, biggest company?
You start by regulating the largest use cases, not necessarily biggest companies
use cases.
just discussed, right? And so in that sense, I actually think you might want to start with the biggest and not necessarily die on that battle, but at least start with a very cooperative agenda and say, like, look, we would like to regulate this, this is how we're going to go about it, because it will start to clarify many of the pieces that come into place. And also, if you're dealing with a small number of people, chances are you can get to some reasonable conclusion. And particularly, if you're striving for a lot of parity with the GDPR, then folks are already compliant with those, I think would be able to help out more in getting those clarity into the Indian system as well. And that's also sort of builds up case law and then helps future cases come into being. But I do think it has to be given time. And
so ease into it is what you say.
Ease into it, yes.
All right.
So, on the question of who will man it, like, of course, or woman it, you'll obviously have, like, people who will come and go, and therefore our philosophy, at least the thinking in NIPFP, has been that you need to concentrate on the process, because you will not have control over the people. You may have control in the first set of people you appoint, but going forward, it's what's in the law in terms of what accountability mechanisms you've built in, what transparency mechanisms that you've built in, which will drive the running of this body. And if we look at the law as it currently stands, it's very weak on many of these counts, right? So it doesn't have a requirement in the law that the authority will exercise transparency in the discharge of all of its functions. In modern regulatory setups, even in India, that's kind of become the norm. If you look at something like the Telecom Regulatory Authority, or you look at the Airports Economic Regulatory Authority, or the most recent Insolvency Board, all of them have requirement of doing certain levels of transparency, sometimes even more, like it specifies doing cost-benefit analysis, and regulators have gone and codified, how you will go around doing that process. And this law is really weak on those fronts. And the other thing is on, the kind of powers, the vast variety of powers which have been clubbed into this one authority. So something we brought up in our comments to the bill was that you need to segregate the compensation and redress mechanism from the regulatory and supervisory functions of this body, because clubbing these two in one body means that you'll be flooded with the kind of problem Sunil was talking about.
I think regulation and enforcement need to be separated from each other.
Regulation and enforcement when it comes to supervision and enforcement of the regulation versus your day-to-day problem. I didn't get this adequate notice. I didn't, I suffered this harm. Those kind of things which are individual complaints need to be segregated in a specialized body, because redress is a specialized function which requires a different capacity to, deliver on. So that's another weak thing in the law.
Does it have to be a separate entity, or can it be a department within the authority?
So ideally, it should be a separate entity, something like an ombudsman service being created separately, which would specialize and do, precisely and only this function. Because there is a possibility of a conflict between these two functions, right? If a lot of complaints are coming on a particular issue, one...
RBI regulates and enforces, TRAI regulates and
that's
enforces.
That's worrying. So TRAI doesn't do individual redress.
These are some of our most storied institutions.
So TRAI doesn't have the power to do individual redress, so they don't have that function.
Don't tell R.S. Sharma that. But please, sir.
Sure. So I'm probably the least qualified on this panel to talk about who should be the regulator, so I'll graciously dodge that part of the question, but do have a lot of experience with different regulatory models around the world, and so I'll maybe identify 3 attributes of a regulatory approach that I think would be effective. As I said before, one, the fundamental thing that a company like Facebook needs to get out of a regulatory engagement is to understand what's expected so that we can meet those expectations. And so one of the things that drives that is to have an ongoing dialogue with the regulator and to have a collaborative approach where we can tell them what we're doing, they can give us feedback, and we can try to meet those expectations. I think the challenging places are where we don't have the ability to talk about what we're doing, and we don't find out until somebody believes that we've done something wrong. And so I think as much as we can have an ongoing dialogue, that's really valuable. The other thing that's important is technical expertise. we do better when our regulator understands our business, understands the technology that's typical in our space and what we're doing that's different, and can understand what the privacy implications are, again, so that they can prioritize their regulatory activity, but also so they can give us concrete feedback that we can action. And then finally, one of the things that you mentioned GDPR, Sanjay. One of the things that GDPR is aiming to address is a number of different regulators that are regulating the same conduct that might have different interpretations. And I think having a single regulator that is empowered to interpret what the Indian data protection law requires is really important. Again, going back to my point that if we're able to go to somebody and say, what is it that you want us to do, and they can tell us, we can like it or not like it, but understanding what's expected is really important.
Yeah.
If you have a lot of different regulators that might have different interpretations, you get in a place where it's harder to achieve that compliance.
You're pulled in different directions, and that doesn't allow you to go anywhere. Excellent. No, I think we'll take a pause here. But what I'm hearing on the data regulator is the first thing that I think pretty much everyone said is be consultative, be collaborative, help people comply. Don't go out there with a vengeance and try and show everyone the law. So I think that's something that is really going to be very key to the attitude of the regulator, the way the regulator approaches it. I think the point Smriti raised around having certain processes, particularly around accountability and transparency enshrined in the law, might be prudent. There is, of course, a point of difference on whether the regulator and the enforcer should be separate or not. I don't know if everyone agrees. But I think the need for somebody, for an entity like this, staffed by people who are competent and understand the subject, and therefore where we are going to find the talent remains to be seen, is something that is crucial. We have time for maybe 2-3 questions, a couple of questions. The lady there in the center.
Thank you very much. My name is Marian, professor at CMR University in Business, Society and Change, and I have a particular question for Mr. Sunil regarding transparency in the insurance. In my previous life, I was working and living in the Netherlands approximately 10 years back, and part of the transformation regarding transparency in all the data of insurance. For example, you are a client and you pay your fee, not only to the insurance company, but also to the intermediate. And after a conflict, of course, between the regulator and the insurance company and the clients, there was an increase of transparency. That means you know exactly what is the cost billed in your fee. And I understood that my intermediate has a different cost than I expected, for example, 150 and 200 euros per hour. So then the impact of that transparency is that you immediately start rethinking, do I need that insurance and that intermediate? Now, the game in India is totally different. Of course, I have my insurance, I pay the fee, I don't know exactly what I'm paying for, and the game, when there's a damage or an emergency, is totally different because you have to run after your money, of course. Now, my question to you is, suppose the transparency in cost in the domain of insurance will increase. What do you think is the impact on decision-making of all the clients?
So basically, if I were to...
I mean, the question is specific to insurance, right? I know very
little.
It's
more.
No, it's more around, if I may,
exactly.
it's more around, you suggested that the people that the intermediary should earn from should be from the group that they are supposed to protect.
Yes.
So in the specific case of insurance, you mentioned that we should charge the people instead of charging the insurance companies, because if I charge the people, then I'm more bound or morally bound, so to speak, to protect the interests of the people. Therefore, the question is, when you layer this as a cost, as a fee, saying this is the fee of me managing your data, as opposed to something that is paid to me as channel commission as a function of the ticket size, right? So if I'm giving a loan or an insurance policy of 1 lakh rupees, I as an agent, you would earn 1,000 rupees or 1% from the insurance company and have some trail revenue. Instead of that, the same 1 lakh policy I'm selling to you, and I'm telling you, look, I used to get 1,000 rupees from these guys. I'm now asking you for that same 1,000 rupees. What does that mean for costs for the individual? How does that impact an industry when you start looking at it that way? That's a proposal that you made.
Yeah. So I think there are many individuals that might choose to deal with a data controller without an intermediary. Yep. So that is a possibility. What I'm most concerned about is welfare delivery. Yeah? And welfare delivery is to the most vulnerable population in the country. A lot of them illiterate, very few of them speak English. Even if they can speak English, they don't know enough law to understand.
We know the demographic, right.
So for that particular demographic, the protection of their rights can be part of the welfare. So you can only deal with the state through an intermediary. And if you don't like the current intermediary, you can always shift to another intermediary. So a percentage of the total welfare bill is a business opportunity for a new set of actors that never existed before. So it's unlike the transition from insurance, where there's an old regime and a new regime. Previously, nobody got paid to provide this service. Here we are creating a totally new set of actors to provide this service.
Previously, the service didn't exist.
You might decide not to use the intermediary to deal with Facebook.
Right.
But if the intermediary starts offering options, like saying, I can make sure that Facebook deletes all your children's photos, yep, then the intermediaries begin to compete. Now, the group of people that first started using the intermediary purely for welfare will say, hey, I can get some services from this intermediary also from Facebook, and so on and so forth. So then the business case for those intermediaries begins to establish itself.
Sanjay.
So I actually have a view that a lot of innovation is really about bundling, unbundling, rebundling,
Yes, of course.
and so on.
The famous Andreessen quote, right? Yeah. Two ways to make money in business. One is bundling, the other is unbundling.
Exactly. And so now...
It's true, they said that.
And it's correct, right? So that's really what a lot of innovation is around, and business models go around that. And I actually don't think that a law should be responsible for specifying a very specific business model, because that should be left to the market. Now, that being said, we've known markets are inefficient. And so at least what you've seen in the early data fiduciaries is that the fiduciaries are controlled by a regulator who is sort of specifying a certain business model. At the least by saying that, A, you cannot offer any other service. So that's the case with the NBFC AA, where the NBFC AA is prevented from offering any other service. So hence, they can't unbundle, rebundle, they're one service. And we'll see how that plays out. But I think the law should specifically stay away from being prescriptive about business models.
From being prescriptive about who can charge whom for what and so on, that's a
Right,
question.
that will change with time, and it'll see how, we'll have to see.
I think
how
Sunil disagrees
So
with you
far, the
violently.
market hasn't produced any entities
The
interested in
entity
protecting
doesn't
consumers.
exist, so this is theoretical. I agree with
So
you.
there is clear market failure, as far as I'm concerned.
But the law hasn't come into effect yet. We have, all right, we'll take two questions, one here and one there, and then I'm afraid we'll have to stop.
I was a few minutes late for this session, so I don't know whether this was addressed. In particular, I'm talking about the right to information. Sunil addressed it partly in his concluding comments. But in the previous round, he talked about how some areas ought to be localized, for example, the military and security sector. I find that somehow a little disturbing, because very often in many countries, the military industrial thing seems to cover everything, or can be made to cover everything, and it becomes a black hole as a result. Since you talked about it, or at least I heard you talk about it, for example, with respect to the Rafale deal, now that the judgment is out, anything can be...
What's the specific question, sir? I'm sorry, I'm going to push you to ask for a specific
I'm
question.
asking you about the right to information and how that's affected by some of the proposals that have been made just now. That we have a rather draconian contempt of court law. So if one were to ask any questions about that, then it will be swept aside as, oh, that's
So
military
is your
industrial.
question on how data localization affects right to information?
So I want to ask Sunil, and someone else might want to answer that as well. How does data localization handle such issues?
Anybody want to take this? How does data localization affect right to information or any other topics that the state might want to kind of keep under wraps? But
I can give one answer to that, which is that if the data localization ensures there's a local entity that has the data, there's at least a point at which you can enforce it. Beyond that, I really have no other views on that.
sure.
So I can't draw the link with localization, but of course with protection of personal data and right to information, there is a conversation going on that one of the grounds for not giving information out is when personal data is involved, and that's one of the exceptions given under the Right to Information Act. But specifically linking it with localization, I don't know what the link is and what Sunil had in mind if he had something
Fair
to
enough.
add.
So if you use Twitter Saver and complain to the police, then your complaint is held by Twitter, and later if you file an RTI request for that particular complaint, you can't get it because Twitter has that data and the Indian government does not have that data.
That's interesting.
So at the moment, RTI is broken because of the infantilization of Indian e-governance by corporations like Twitter.
Okay. One last question there in the corner, and then I'm afraid we'll have to stop. We're out of time.
Hi, my question is to all the four panelists.
Please
So we
introduce
have,
yourself.
yes, I'm Tanvi, I'm from Ernst & Young. And my question is that, so India's been in the internet age for now almost 2 decades, and we're finally talking about data. But this is coming at a time where the speed of disruption is such that we're moving to, say, a Web 3.0 now, which, say, in 10 years will be a decentralized web, right? Where data ownership model will be completely different. So is there perspectives from you, since you have great perspective on current regulatory approaches, on how India can prepare for the future? And is there hope that India will be prepared for the future of technology?
Question really is, are we finally building highways for 5 years from now, or are we going to build a highway and then realize that we're traffic jammed 5 years from now? Right? That's the...
I have a simple view. The only way to prepare for the future is to build it. So I would actually encourage all the innovators and entrepreneurs to decide what the next 10 generations, 10 years of the internet is going to be like. Why should we wait for somebody to come and impose an internet on us for whatever it is worth? And if you're not able to do that, then we deserve what we get.
Any final comments, folks, before we close?
Yeah, I mean, I would say in response to the question, I think it's really exciting and positive that we're having this conversation and that people are sophisticated and thoughtful about their data. I think that's to all of our advantage. I think the way that you do this well, which I think is the direction that the discussion is going in, is thinking about principles and thinking about the rights that people should have independent of particular technologies. And I think, anticipating the fact that technology will change, we will find new ways to use data. AI, which we haven't talked about on this panel, but which I think is coming up later in the agenda, is a really important aspect of this, making sure that we leave room for data to be used in new ways that benefit people and technology to be built is a really important component of the discussion. I think we're seeing that. But I think the result of this will be not just in sort of what a legislation looks like, but as you say, Sanjay, in how the legislation leads to the development of services that benefit people and that empower people. And I'm really excited to see what happens with that.
Excellent. We'll end on that note of empowerment to say that we should be building the future. And this was an exciting and fun discussion. Thank you so much to everyone for joining us. And we'll be around, so look us up. Thank you.
Thank you so much. We're breaking for lunch now, which is served right outside the venue. We request you to please come back to the venue at 1:30 sharp. We'll start our next talks and panels at that time. Thank you.